Hello, my name is Ian Larkins of Radius Law and welcome to our monthly commercial bulletin brought to you in association with LexisNexis. The recent case of Revel Independent LLC, a US TV company, and Anatech International UK, a distributor of cookware, is another illustrative reminder that a contract does not need to be signed to be binding. The agreement was documented in a deal memorandum. Now, the parties had intended the deal memorandum to just be the initial document and that a more detailed agreement would be created. The deal memorandum was not signed by Revel and the more detailed document was never created. Revel sued alleging that Anatech had not fulfilled its side of the deal, but Anatech defended, saying the deal had not been concluded. Now, cases of this nature are not unusual, but this is interesting as the deal memorandum specifically stated that it was not to be binding until signed by both parties. Further, there was a handwritten amendment by Anatech that stated branding conflict with Gordon Ramsay to be concluded. The judge, however, stated that it was clear that the contract had been accepted by conduct, particularly as Revel had already incorporated Anatech's products in the television series and Anatech had marketed some of its products using the MasterChef logo. In relation to the Gordon Ramsay conflict point, Anatech argued that this had not been resolved and was a fundamental precondition to the contract. The court, however, stated it was clear to everyone when the deal memorandum was created that the parties' abilities to restrict the brand conflict was limited and therefore could not have been a key condition of the contract. In another case of Raymond Bieber and Oars versus Tethers, it was held that an email that simply stated "noted with thanks" was enough to confirm acceptance of the offer to settle a court dispute. The parties in this case had been attempting to resolve a dispute as the court hearing was just days away. The claimant's solicitor emailed the defendant's solicitor stating it would accept the defendant's recent offer and that it would issue a settlement agreement the next day. The defendant's solicitor responded, "noted with thanks." The settlement agreement was then rejected by the defendant as it did not include some of the detailed points that it considered important. The court, however, ruled that the settlement agreement had already been agreed by the email exchange, and if the defendant's solicitor had have intended it to be subject to the detail of the formal document, then it should have clearly stated that it was subject to contract. The Consumer Rights Act has now received royal assent and is due to become law in October. The Consumer Rights Act, the CRA, replaces 8 existing consumer laws, including the Sales of Goods Act and the Supply of Goods and Services Act. We'll be covering more information on this new legislation as the implementation date looms. But for now, we just wanted to flag the Trading Standards Business Companion website that has recently been launched and has been purposely designed to quickly and easily find and understand trading standards laws. For criminal offences committed after the 12th of March 2015, the Magistrates Court will no longer be restricted to the maximum fines for the vast majority of offences. This will affect health and safety, trading standards, environmental, food safety and other regulatory offences for both corporates and individuals. This will inevitably lead to a risk that penalties for breaching these laws will increase. The ICO has found that the Universities and Colleges Admission Service, UCAS, breached electronic marketing rules and has required UCAS to change its practices. In this case, if applicants wanted to opt out of marketing from commercial companies, they would also opt out of receiving information about careers opportunities, education providers and health information, whereas the ICO would expect for users to be able to opt out of a different subsets of information. We think this is an interesting case as it demonstrates that opt-in and opt-out boxes need in some cases to have an added layer of complexity, dividing between the different types of information. European privacy regulators have recently published a report on cookie usage. A cookie is a small piece of information placed on a person's computer when they visit a website. To some, they are helpful in remembering the user's preferences, but to others they are an irritation, particularly when the more intrusive cookies are used that track a person's browsing habits. The report revealed some concerning results, particularly that some cookies are being set with an expiry date of almost 8,000 years. 26% of the websites surveyed provided no notification that cookies were being used, and only 16% of websites gave a granular level of control to accept a subset of the cookies. The Privacy and Electronic Communications regulations require organisations to provide clear information about how cookies are used on their websites and to allow the user a real choice about whether they are willing to accept them. Given that the report has had some negative findings, it is likely that the ICO will be looking to take some further action on companies that have non-compliant websites. The requirement to publish details on the difference in pay between male and female employees for private sector employers with at least 250 employees will become law in March 2016. The consequence of this is to be seen, but we anticipate that it may trigger equal pay claims and the media will be keen to expose companies where there is an unexplained pay differential. Naturally, if your business is caught by the reporting requirement, it will make good sense to review your pay practices now. As some of you may recall, back in 2013 there were some important changes to UK whistleblowing laws. The key change being that an employee would only be afforded protection where the employee reasonably believes it is an issue of public interest. What is public interest has recently been tested in the case of Chesterton Global v Noor Mohammed. In this case, Mr. Noor Mohammed was a director of an estate agent and raised allegations with two of his senior managers that he believed the company had manipulated the accounts to reduce commission payments to himself and over 100 other managers. Mr. Noor Mohammed was later dismissed and he brought claims of unfair dismissal and detriment arising from the whistleblowing. The Employment Appeals Tribunal was satisfied that public interest was not intended to mean the whole public and that 100 managers was a sufficient group to satisfy the public interest test. The Employment Appeals Tribunal also made it clear that the test is not whether something is in the public interest, but whether the individual making the disclosure had a reasonable belief that the disclosure was made in the public interest. As an aside, it's worth mentioning that the Department for Business Innovation and Skills, BIS, has issued guidance and a code of practice to help employers better understand whistleblowing laws, and we've included a link in the written version of this report. We have previously reported on Locke versus British Gas Trading case. This case concerns whether an employee whose salary consists of basic pay and commission should be paid an average commission during the time he or she is on holiday. The European Court has been clear that holiday pay must correspond to the normal remuneration received by the worker. This case was then returned to the UK Tribunal and a hearing was held in March to determine a number of questions as follows. Point number 1, whether the UK working time regulations are consistent with European law. 2, if yes, did the commission scheme in question operate in a way that effectively compensated Mr. Locke? Number 3, if holiday pay is due, what is the correct reference period? Number 4, whether commission is payable for 4 weeks or 5.6 weeks. The issue here being that UK law enhances an employee's statutory holiday rights from 4 weeks to 5.6 weeks. And number 5, what is the quantity of the claim? The Employment Tribunal confirmed that the UK working time regulations are to be interpreted as being consistent with the European law, and therefore commission pay is to be included in holiday pay, but this is only for 4 weeks holiday pay, not the 5.6 weeks. The other questions were deferred to another hearing. Perhaps the most interesting item will be whether rolled up commission pay will be permitted, i.e. where an employer argues that the workers' commission structure is higher than would otherwise be the case to take account of holiday periods. The Competition and Markets Authority, the CMA, has issued 2 new guides. One of the guides is for company secretaries on how to comply with competition law when fulfilling corporate responsibilities. The guidance includes advice on identifying actions which could put businesses at risk from competition law, as well as providing information on how to assist companies in moving towards an effective compliance strategy. The second guide concerns CMA's leniency policy, particularly that the first businesses to inform it of a cartel that is not already being investigated will receive guaranteed immunity from fines and protection from criminal prosecution for all cooperating employees. Thank you for joining us for this month's Commercial Legal Bulletin. The videocast and podcast are available to download on the website together with the written report. The website details of Radius Law and LexisNexis will be shown on your screen shortly. We'll be back next month with another update. Until then, thank you and goodbye.